All right, we're going to get started. And again, I apologize for the delay in getting started and the delay in getting those of you who registered for the event that Zoom link. But hopefully, if you're here, you have it. And if not, we're recording this. And so we'll upload that recording to our YouTube channel. So you'll be able to watch it in a delayed way, but nonetheless, be able to stay up with the conversation. So welcome everyone to our webinar / CLE for World Day Against the Death Penalty 2024. Every October 10th is World Day Against the Death Penalty. And we are here today to talk about some really exciting work and some exciting progress toward abolishing the death penalty worldwide. With that, we'll move to introductions. And my name is Amy Berquist. I'm the Associate Program Director for the International Justice Program at the Advocates for Human Rights. And I represent the Advocates for Human Rights on the steering committee of the World Coalition Against the Death Penalty. And I also, for many years, have chaired the World Coalition's working group for World Day Against the Death Penalty. So today is a really big day in my professional life every year because we spend many, many months in the lead up to World Day Against the Death Penalty, getting everything ready. So literally this process for today began last December with the steering committee selecting a topic and then developing the poster and the slogan and all of the supporting materials. And this event that you all are attending right now is one of hundreds of events around the world, all sorts of different things that are happening with World Coalition Against the Death Penalty members, trying to raise awareness and visibility of death penalty issues and why we should be moving as a global community toward abolishing the death penalty. So it's a really exciting day, and we're really glad for you to be a part of it. Just to give you some ideas of other things that people are doing, our colleagues in Pakistan have developed an escape room for World Day Against the Death Penalty to highlight all the different human rights violations throughout the process of being sentenced to death in Pakistan. Other colleagues in Taiwan are doing film screenings and post-film discussions. Then there are events like ours. Others are doing debates with university students and press conferences. There are all sorts of activities happening all around the world to commemorate and celebrate World Day Against the Death Penalty as this global day to focus on abolition of the death penalty. So you're just one part of a really big movement that's happening today. Look for it on social media as well. The hashtag for today is No Death Penalty. So you can join in and see what others are doing and saying for World Day Against the Death Penalty. So it's really an exciting part of the abolitionist community. And with that, I want to introduce our two speakers today, and I'll say a few remarks before handing over the floor to them. Our keynote speaker today is Tito Magoti, who holds a bachelor's degree in law from Mzumbe University, as well as a postgraduate diploma in legal practice from the Law School of Tanzania, and master's degrees in human rights from the University of York in the UK and the University of Pretoria in South Africa. Tito is an advocate of the High Court of Tanzania and proprietor of Law Dons Consult, which is a law firm based in Dar es Salaam, Tanzania, that does consulting on human rights law and development. He's also associated with the Legal and Human Rights Center, which is an organization that's a member of the World Coalition Against the Death Penalty and is Tanzania's leading human rights advocacy body. Tito won the U.S. State Department's International Visitors Leadership Program's Impact Award for his project on the right to bail in Tanzania, and he has achieved significant litigation success on human rights issues, including a challenge to Tanzania's Data Protection Act and a complaint to the UN Working Group on Arbitrary Detention, challenging his own abduction and imprisonment due to his human rights work. He also has considerable expertise on the workings of the African Court on Human and People's Rights, which is what we're going to hear from him today. So we'll hear from Tito in just a moment. And our other speaker is Chris Hart, who holds a BA from Harvard University, a master's from St. John's College, and a JD from Duke, where he graduated magna cum laude and Order of the Coif, and then served as a judicial law clerk for the Honorable Anthony Sirica, who was at the time the chief judge of the U.S. Court of Appeals for the Third Circuit. Chris is now a partner at the law firm Foley Hogue and co-chairs the firm's privacy and data security practice. He has extensive experience as a civil litigator and a human rights lawyer, focusing his practice on cybersecurity and global data protection. Chris conducted an extensive human rights investigation in Honduras for a client, and also conducted a human rights impact assessment for Microsoft relating to cloud and AI technologies. And he was recently named one of the best lawyers in America for privacy and data security law, and also earlier received recognition from the Washington Lawyers Committee for his work as lead lawyer on a pro bono civil rights matter that resulted in a significant settlement. He is also currently part of a pro bono team at Foley Hoag that is doing work for the Advocates for Human Rights that you'll hear about in just a moment. So with those introductions, what I'd like to do is say a little bit, I'm going to stop sharing my screen now. I wanted to say a little bit about a really exciting development that happened today, and that is a filing with the African Court on Human and People's Rights. This is a filing that's led by the Pan-African Lawyers Union, which the name seems pretty self-evident, but they have filed a request with the African Court on Human and People's Rights seeking an advisory opinion that the death penalty is not compatible with the African Charter on Human and People's Rights. So this is their big activity for World Day Against the Death Penalty. And of course, they've been working on it for quite some time. And today is filing day. So we're really excited about this. The African continent has seen huge progress over the most recent years toward abolition of the death penalty. Just thinking about the last 3 years, we've had abolition of the death penalty in Sierra Leone and Zambia. Ghana has abolished the death penalty for ordinary crimes. And we're seeing significant movement, in particular in Kenya. We're really optimistic that next year is going to be the year because they made commitments 5 years ago to abolish the death penalty, and they should be on the verge of doing so. And we suspect that Liberia will be next as well. So there's been a lot of really good positive movement toward abolition of the death penalty in Africa. And I'm really hopeful that this litigation from the Pan-African Lawyers Union will help move the ball forward even further by demonstrating that the death penalty isn't compatible with the African Charter on Human and People's Rights. We'll hear more from Tito about what that means, how you can seek an advisory opinion with the African Charter on Human and People's Rights, and what this type of litigation is, because I think for a lot of people who practice law in the United States, our courts don't issue advisory opinions. That's a really big part of sort of the common law, is that courts can't sort of step in and proclaim opinions about whether something is constitutional or not without a case or controversy before them, without, a plaintiff and a defendant, for example. But it's a little bit different with the African court, and we're going to learn about that today. So that's exciting. And another thing we're going to learn about is the process of being an amicus curiae, or friend of the court. Now, that's something that US-based lawyers and common law lawyers are familiar with, is being a friend of the court and how that works. And part of the really important, exciting news that we're going to talk about today is that the Advocates for Human Rights is taking the lead to prepare an amicus curiae brief in support of this advisory opinion request. And so Chris is going to talk a little bit about that, because his firm is representing the advocates in preparing this amicus brief, and we'll talk about it. And one of the things that's really exciting is because it's a perfect fit, our amicus brief is a perfect fit for this year's theme for World Day Against the Death Penalty. Each World Day has a theme, and this year's theme is the death penalty protects no one. And when we came up with this theme back in December, people were talking about how governments will use issues like the need for safety and security as a pretext to justify the death penalty. And so that's the whole idea of the death penalty protects no one, is the death penalty doesn't provide the promise, it doesn't fulfill the promise that a lot of politicians make, which is that we need the death penalty for our own safety and security. So Chris is going to talk about those connections and how they're relevant to the amicus brief that Foley Hoag is preparing on behalf of the Advocates for Human Rights to support this important litigation that was just initiated today. So that's a little bit about sort of where we are, what we're doing. And now what I'd like to do is turn the floor over to Tito to tell us more about the African court how advisory opinions work with the African court, how amicus briefs work with that court, and then how the court would go about assessing whether a practice like the death penalty is compatible with the African Charter on Human and People's Rights. So Tito, we'd really love to hear your expertise and help us better understand what this process, what this procedure is like, and any other insights you can share based on your expertise with that type of advocacy.
Thank you so much. I'm trying to share my screen. Give me a second. Is my screen visible?
We might need to give you permission to do that. Let's see if there's a way.
I think so.
Are you able to request that permission?
Permissions have been granted for everyone to share screens.
Thanks, Nathan. Nathan is my colleague who's providing some tech support.
Oh, I saw as well supposed to grant permission for my settings. Couldn't reopen and I don't know, cancel. Yeah, I think now I can. Yes, now I can share. Is now visible, I guess.
Yes, it's perfect. Thank you.
Yeah, so thank you so much for having me today. I was to say this evening, but I understand it's afternoon somewhere in the US. My introduction has been made, and I'm happy to be sharing a bit of the nuances on how to litigate advisory opinions before the African court. So briefly about the court was established by the African Court Protocol in 1998. It started operating in 2004 after ratification by 15 member states, which was a precondition for ratification. The court was established to complement the protective mandate of the African Commission. It has jurisdiction over all cases and disputes submitted before it concerning violations of the rights contained under the African Charter on Human and People's Rights. The court can be accessed in so many ways, but through the African Commission, because it was established to complement its mandate. So it's one of the means through which a communication or a complaint can be brought. So ordinarily, an applicant or a complainant would present their complaint before the commission, and then the commission will be able to entertain it and probably forward it to the court. State parties can also submit or appear before the commission, but also there's a room for individuals and non-government organizations with observer status before the African Commission. They can also prefer disputes or complaints before the court. But the precondition is that a state has to have deposited a declaration to the effect of allowing individuals and civil society organizations with observer status before the commission to appear before the court. Briefly about the jurisprudence of the court on death penalty. The death penalty before the court has been litigated majorly based on two articles, especially the article relating to the right to life, Article 4 of the African Charter, but also it has been litigated in terms of its means of execution amounting to cruel, degrading, and degrading treatment or torture, which obviously is related to the mode of executing the death penalty. of interest in, because I come from Tanzania, we have been massively, I mean, my country has been massively litigated before the court, with almost 16 decisions. That much I can recall as of July this year, for 16 decisions on death penalty against Tanzania, where the court has ruled that Tanzania's death penalty practice is incompatible with the African Charter because it arbitrarily deprives one's life, contrary to the Charter, which guarantees the right to life, but also that its way of execution. You know, in Tanzania, death penalty is executed by, it is death by hanging. So you are hanged until when you die, and if you don't die, you'll be shot until you die. So the court has found that, you know, such a practice is incompatible with the Charter, but also, you know, it has classified it to amount to torture, and there's a prohibition of torture under Article 5 of the Charter. Advisory opinions, which is the subject of this meeting today, these are sought in line with Article 4 of the court protocol, but also the rules of the court. And to be precise, Article 4, sub-Article 1 of the court protocol, which establishes the court, gives it competence to entertain applications requesting advisory opinions. Whereas Rule 82 of the court rules of 2020, they were revised just 4 years ago. It also, gives court the mandate to entertain the competence to hear and determine requests for advisory opinions. And who can request advisory opinions? Could be a member state of the African Union itself, but also any of the organs of the African Union, or an African organization that is recognized by the African Union, like the Pan-African Lawyers Union, PALU, which has, you know, a memorandum of understanding with the African Union, but also it has requested quite a couple of advisory opinions before the court, including the one relating to measures taken during COVID. You know, this was one of their opinion they sought before the court. But also the court entertains advisory opinions which are based on a matter that is legal, but it should relate to the provisions of the Charter, the African Charter, or any other relevant human rights instrument that is classified as a human rights instrument. And how this goes beyond Africa, it might do with the international covenants on human rights, on women's rights, on children's rights, and more. But also, there's a precondition that the matter, should be novel, such that it shouldn't have been entertained or examined by the African Commission. And in terms of the jurisdiction of the court ascertains its jurisdiction by itself. This is according to, I mean, if you look at part, I think that is part 4. Yeah, part 4 of the rules of the court. In all advisory opinion proceedings, the court ascertains its jurisdiction and goes forward to decide on the matter. There are also other standards developed at the court, including the fact that the matter should not, the facts shouldn't be contested between the parties. Is when the court can ascertain territorial and temporal. The matter of the territorial and temporal jurisdiction may not arise, but also when the applicants have personal jurisdiction in terms of having for instance, for the case of PALU, Pan-African Lawyers Union, it has, a memorandum of understanding with the African Union, but also it has an observer status with the African Commission, and also it is present in one of the member states. Now, in this case, Tanzania, PALU has, has an address and is registered to run business from Arusha, Tanzania. Yeah, material jurisdiction. It's not a really issue. Not a really issue, but material jurisdiction has to do with the subject matter that is brought before the court, which has to be legal. And in this case, the death penalty is, contravenes several provisions of the Constitution for arbitrarily depriving the right to life. And this is contrary to Article 4 of the court. The court considers an application for advisory opinion admissible, considering the subject matter, but also, if the subject matter is not being examined by the commission, as I said earlier, but also the applicant has to specify the context or background giving rise to the request. Names has to be specified. The names of the representative themselves has to be specified, but also the entities making the request, including the author of the opinion themselves. And in this case, it's easy for organizations like PALU, which I'm a member. Yeah, I've said this already. Yeah, so the court oftentimes look into the compatibility of the application or the request, considering the fact that whether the practice or whether a law or a state practice is compatible with the Charter or international human rights law, because this is part of the instruments that the court use. But also the court oftentimes sanction rights against the African Charter, and there comes a challenge, which Paolo and Chris, really seeks to raise a debate upon whether the Charter itself, is substantive enough in terms of guarding the right to life and prohibiting death penalty. Yeah, but also the court oftentimes relies on its jurisprudence. I have seen all the decisions on death penalty against Tanzania. The court almost replicated the reasoning, so it's like they're doing a copycat kind of a game. But I think it's they are trying to rely on their jurisprudence that they laid earlier. But also there are times where dissenting opinion of judges, like the judge who is famously known for dissenting opinion, Justice Blaise Chikaya, whose tenure was renewed a month ago. This judge have always had a different standing on death penalty, and I think it's quite pertinent to try to read his reasoning. And he thinks that there's a way death penalty practices among states can still be permitted, to the extent of his reasoning. Procedure, these are ordinary issues. Notification of the entities within 90 days, they should have responded. Member states also might, oftentimes they're given 45 days. I know this is always a hassle, especially for states which have litigation fatigue. Like Tanzania, I know they have been requesting for extension, but the practice is 45 days. I'll speak about AMIC in the next slides. But also, if you apply for being an amicus, you have got to participate in the matter, filing briefs or arguments, but also to the finality. Yeah, so I think I've said this. But also the court, considers questions whether related to the court jurisdiction. This goes back to the question of jurisdiction. But also in our case on death penalty, then the key issues in the court has always been the right to life, and whether the way the death penalty is being practiced by member states arbitrarily deprive it. And now looking at the Charter itself, the way the right to life is crafted, it leaves that discretion for member states to at least enjoy the privilege under the clawback clauses, to deprive the right to life based on, operation of other laws. For instance, in Tanzania, the Constitution states that everyone has the right to life, but in accordance with the law. So I think the charter is crafted in a way to accommodate such global clauses, which is why the court has also been, reluctant to outright prohibit death penalty in its reasoning. Instead, for instance, for the most of the decisions, the court has always been saying that, at least you shouldn't have mandatory death penalty. You should retain judicial, prerogative to say, in this case, we are sanctioning this person to death, and in this case, we are not, because of the circumstances. So I think they are rather slowly building the jurisprudence, but they don't seem to graduate from, from this combating mandatory death penalty to going further to combating death penalty itself. Yeah, then amicus. I think I still have like 3 minutes, 3 to 4 minutes. Amicus briefs are permitted under the rules of the court. Rule 45, gives the court the prerogative to, to decide to call any person. This is now the court on its own motion. Can hear as a witness or expert or in any other capacity, and person whose evidence, assertions, or statements it may deem likely to assist in carrying out its task. I remember in the advisory opinion sought by Palu on COVID, the court invited a couple of institutions in Africa, including some of the treat bodies like the African Committee of Experts on the Right of the Child, the women. The women coalitions. I also know that they invited the University of Pretoria, and several other international organizations sought to file amicus, but some of them couldn't go to the finality. I think maybe they lost interest in along the road. Yeah, so an institution or a person. So this is Rule 45.1, also Rule 45.2 speaks to the same expression, but also the amicus may be invited to make oral submission during hearing of the matter. I remember 3 weeks ago this was a hearing on people persons with disability. There was a hearing before the court, and the court. I know we had partnered with some of the colleagues, including the special rapporteur, the UN special rapporteur on people with disabilities and HIV. They were present in court, although they didn't make submission. They didn't make oral submission, but they filed their submission on the matter. So in terms of procedure, which takes me to my last slide, amicus proceedings are governed by the practice directions of the court, section 42 to section 47, and oftentimes the court, if it is not on its own motion, then an amicus to submit, an individual or an organization wishing to act has to submit a request to the court through the office of the registrar, specifying the contribution they would like to make about the matter, and then once accepted, because it's the discretion of the court, once accepted, the registrar will notify the applicant, the amic, that you are now accepted. You can make your submission, but also you'll be supplied with all the copies of the proceedings. Yeah, so that's it. That's a bit of what looks like in our system, and I know this was brief, but I hope it is useful in a way of trying to shed light on what is happening on the ground.
Thank you so much, Tito. That was really fascinating. Before I hand off to Chris to talk about the specifics of of the amicus brief that the advocates is working on. I'm wondering, Tito, if you could just talk briefly about how common is it for there to be amicus briefs with the African court, and do they seem to have any effect? Does the court actually quote those amicus briefs? Do they seem to be influential?
Yeah, of course, they are influential, because I think the court is a bit flexible in terms of appreciating professional contributions. Because even in ordinary proceedings, they tend to borrow experience from professors on the continent. Like Professor Franz Villion is quite often referred to in the proceedings of the court. Although I know that some judges are opposed to inviting, I would say, thinking from other jurisdictions, like the practice of the European Court, which Justice Blaise Chikaya tends to refer to because he was educated in Europe, so he tends to borrow the European standards. But then the biggest criticism on that has been that, he is not contextualizing it. He's just borrowing experience without now, showing why is this necessary in our jurisdiction. And now, with the death penalty advisory opinion, now we are going to let me use the word attack, to attack the charter itself. So some dynamics might be who is better placed to comment on the context of the charter, So those complexities might arise, but also apart from that, but the court is always flexible in terms of, inviting certain thinking, provided that they also try to bring like a reason as to why this should be applied in Africa.
Great.
Yeah, and Chris will I think Chris is in good hands of people like Don Dare. Don Dare knows how to navigate in all those corridors, and he has known all these judges and the way they think, because sometimes you have got to know what the judges think about. Yeah.
Right. Well, thank you so much, Tito. And we'll have a Q&A session at the end, so we'll be able to hear more from you. I'm sure people will have questions. If they don't, I definitely do. But Chris, we want to hear from you now about the arguments connecting, because the death penalty protects no one, this year's World Day theme. How does that show that the death penalty is an arbitrary violation of the right to life under the African Charter? Because the African Charter, like other international human rights instruments, says you can't have an arbitrary deprivation of life. So Chris, why don't you sort of talk us through what the arguments are and what you think might be particularly resonant with the African court with respect to the subject of our amicus brief.
Great. Thanks, Amy. Tito, thanks very much for your comments and setting up what's, frankly, a very complex set of processes into a distillable, understandable format. I really appreciate that. And Amy, before I answer that question, I also want to indicate, although I'm the one speaking for Foley Hoag, and by the way, we're thrilled to have been able to represent the advocates in preparing an amicus brief. I'm just one of a team of 6 of us who has been working on this. And in fact, just to embarrass her for a moment, I see in our participants list my colleague Isabella Uria, who's an instrumental individual both in preparing the brief and in preparing my comments. And so we were really a terrific team. The other thing I want to say, just as a preliminary kind of table setting, is especially taking the last bits of your presentation, Tito, what's interesting to me, I'm a US lawyer. I'm licensed in 3 states. I've done a lot of federal and state court appellate representation. And there's a lot that's quite familiar in what you were presenting. In other words, it's quite common in state and federal courts to seek leave for an amicus brief, to tell the court why it is that you will present a unique perspective It's common in state courts in particular to have solicitations for amicus briefs, especially to specific organizations. And they can offer, just as a general matter, right, a wide variety of different perspectives that you're not going to get in the principal merits briefs. And sometimes those can be policy perspectives, sometimes those can be different legal perspectives that weren't fleshed out. And so what was interesting to me in listening to this and listening to you speak was, you know, the similarities across different kinds of courts. So all of that out of the way, the amicus brief that we have, and by the way, I go back and forth between amicus and amicus, so I apologize. The amicus brief that we have been working on for the advocates focuses on the question of deterrence. And I'll tell you what the arguments are, and then I'm going to go back to sort of, you know, what's the legal hook for talking about the arguments. It's this question of arbitrariness. So the deterrence question, you've all heard, I think, the defense of the death penalty. One of the defenses of the death penalty is being it's a strong deterrent against crime. It helps prevent crime, it helps minimize crime. And the amicus brief that we will propose to submit really takes aim at this question, tethered to this question of arbitrariness under the charter. So the first point here is that there is no credible evidence that the death penalty in fact deters or reduces crime. The second is that there are alternative criminal justice policies that have greater deterrent effect. And then at the end of the day, the third argument is that the death penalty is a disproportionate sanction. So I'm happy to get into the details there, but let me link it back now to this question of arbitrariness. So you're right. We could, I suppose, just ask to submit a brief focusing on untethered policy arguments and hope for the best. But linking it, and I think as Tito made clear, really do need to link it to the legal hook so that it can carry weight. You know, what we really focused on is on Article 4 of the African Charter that says human beings are inviolable. Every human being shall be entitled to respect for his life and the integrity of his person. No one may be arbitrarily deprived of this right. Okay? So the question then becomes, what is an arbitrary deprivation, right? It doesn't say, it's not an absolute, right? There are permissible deprivations of life. So the question is, what is an arbitrary deprivation? And this is, you know, in our research and our drafting, this was a surprisingly complex issue to unravel based on the court's jurisprudence and on other guidance. So first, the way we thought about it, the first sort of underlying point is the first sentence of the article, which is human beings are inviolable. The point there is, and where we really have focused the frame is, there are no other rights that are available unless you first have a human life that you're talking about, right? So this is the fundament for any other right. So that does give it some special significance. And the reason that this matters, and the African court has said, quote, the right to life is the cornerstone on which the realization of all the rights and freedoms depend. And it matters because the court's also found, and I'm quoting, such strongly worded provisions for the right to life outweighs the limitation clause, right? So there are going to be really few instances where we can find the limitation clause is going to overcome. So there's no definition of arbitrariness under the charter, so that's a significant issue that we need to overcome. And up until now, the court has not examined whether the death penalty is inherently arbitrary, right? So there are important points, though, that we were able to highlight from past cases. First, the court reiterated in multiple rulings that the compulsory death sentence is arbitrary. the compulsory death sentence is arbitrary. So, for example, the court determined that Tanzania's law that someone who is convicted of murder must be executed was arbitrary and therefore violative of Article 4. Okay, so its reasoning there was that the compulsory death sentence was arbitrary because it deprives a judge of discretion to determine if the death sentence is proportionate in light of the facts of the case. Again, we're thinking about, if it's compulsory, then it's sort of inherently arbitrary, right? It also explained how to assess what makes a restriction of protected right arbitrary. So in one case, the court examined whether the restrictions on the right to physical liberty were arbitrary or not. This is Onyachi and Nyoka versus Tanzania. In that case, the court said that the restriction of a protected right, like the right to physical liberty, will not be arbitrary if it is, and this is a quote, just, necessary, proportionate, and equitable. So right there, we've got a way that we can benchmark the question of, is something arbitrary or not? Just, necessary, proportionate, and equitable. Some of the difficulties that we have in sort of teasing this out is that, and I won't go into a lot of the details because I only have so much time, but some of the standards kind of feed into other language. So here we've got a four-pronged test on whether something's arbitrary, but then the question is something arbitrary and reasonable based on sort of other language? So if part of the test is arbitrariness includes reasonableness, but then there's a separate reasonableness test, well, how do you suss that out? At the end of the day, while these are important technical points, it sort of boils down to the same thing. And thinking about justice, necessity, proportionality, and equity are important. So in thinking about these questions, we then go back to the three places I started with, and what we really focus the argument on, which is first, no credible evidence that the death penalty deters or reduces crime. Okay, so how does that relate? So this really turns on the second prong of the test. Is it absolutely necessary to reduce crime? Is the death penalty absolutely necessary? So if you look up the phrase deterrence theory or death penalty and deterrence, you're likely to find a lot of studies from throughout the past 100 years that have attempted to show scientifically that capital punishment reduces crime. But there's been a lot of work that shows that this is flawed. There are a lot of studies that have shown that deterrence theory support is scientifically flawed. So first, the question itself has been proven to be nearly impossible to prove scientifically. So part of the scientific method requires that to test an impact of a variable, you have to isolate it as a variable. But what are factors that we can reasonably guess could impact crime deterrence? Various forms of punishment that could be imposed against criminals for the same crime in a country, the frequency with which a death penalty is imposed in the country, how likely a person is to be caught committing a crime, so like the investigative capacity of the domestic police force, the availability of an appeals or pardon process in the country. All of these factors cannot be isolated, right? In other words, we can't take away these, what I'll call contingent, political, legal factors from this question of the existence of capital punishment. And so, and there's really no country that can. So it becomes impossible then to make the comparison point about when is it useful, when is it not, when does it deter crime, when does it not, because so much is bound up in this question of the legal system, in the questions that I've just brought up. And the second is that these studies don't credibly assess the psychology of a potential criminal. So deterrence is this idea that a potential criminal will think about a possible consequence of his or her crime, and the threat of that consequence will cause the potential criminal to refrain from committing the crime. So you can see this sort of causal chain, right? Law, psychological effect, and then a counterfactual argument. So you'd have to then assess how potential offenders perceive the lack of the death penalty and act according to that perception. So a deterrence theory would require that a potential offender would know what the risk is, and know to what extent there's a certainty of that risk. But there's a lot of evidence that shows that offenders actually have a poor understanding of the risk. And so it also requires ultimately the deterrence theory that a potential offender is able to weigh the risks. But there are studies that say that that's really not something that ends up being possible either. I'm conscious of the time because there's so many sort of rabbit holes I could go into, and it's all, I think, very important. But this is just, by the way, the question of, is there evidence that the death penalty deters or reduces crime? And again, this goes to the question of necessity. And I think what I'm hopefully suggesting here, and what's laid out in some detail in the brief, is there is an enormous amount of evidence that says that there is no such evidence, right? There's nothing that a court could hang its hat on to say that this is not an arbitrary deprivation. The second is this question of alternative policies. Alternative policies have a greater deterrent effect. So the court again explained that the restriction of a right is not absolutely necessary if alternative policies that do not restrict that right are available. So in the US, you might see this under strict scrutiny analysis with regard to, is something narrowly tailored, right? Are you using the least restrictive means? It's also in international law akin to proportionality tests, right? So this is sort of a well-worn way of thinking about whether something follows due process in U.S. law, or here in this case violates Article 4. So in a 2020 advisory opinion, the court said, where policy alternatives that do not infringe on individuals' rights and freedoms exist, policies that infringe on fundamental human rights are unnecessary and should be avoided. We argue in the amicus that that's certainly the case with respect to crime reduction. The UN Human Rights Council has studied this question and concluded there is no evidence that the death penalty deterred crime more effectively than any other punishment, such as life imprisonment. And there are studies from the world's leading criminologists on the same issue. And I could go on there. The third argument, the death penalty is a disproportionate sanction. Each one of these, by the way, is an independent basis, right? These are three independently persuasive, dispositive reasons to say that that the death penalty is an arbitrary deprivation of life because it is not an effective deterrent. And that it's a disproportionate sanction is yet another one. First, I think in some ways it's obvious to say that the death penalty is the gravest of potential sanctions. So once you start there and you see that human life is inviolate or inviolable, then by eliminating life for the purposes of crime reduction, you automatically impinged on other human rights. And of course, there are other issues like the potential commission of error and all those other contingent issues that I touched on earlier. So that's really what the amicus brief focuses on. And you can see that the way that we framed the argument was both tethering it to the specific language of the charter, trying to explain the meaning of arbitrariness through existing law, and then bringing in as much policy, social science as possible to flesh out why, as a practical matter, the death penalty cannot act as an effective deterrent. So hopefully I've given you a flavor of what the amicus brief intends to say. Happy to answer any questions about it. And Amy, thanks very much for the opportunity to talk about it.
Thank you so much, Chris, to you and the team at Foley Hoag for all of your hard work on this exciting project. And we're going to have time for questions for those of you who are able to stay past. We started at about 12 after, so we'll try to allocate 10 minutes for questions. But before we jump into that, Chris, I'm wondering if you can talk about the discrimination argument, because I think that's another aspect of demonstrating the arbitrariness of the deprivation of life or the right to life. And you talk about it a bit in the brief in terms of the ways in which discrimination is kind of embedded in death penalty practices. And I'm particularly interested in if you can speak to any of the aspects of discrimination. I think that would be really interesting, because here in the United States, of course, we hear about the discriminatory aspects of the death penalty, but one aspect that doesn't get a lot of attention, and the World Coalition Against the Death Penalty is really focusing on this, is the issue of women, gender, and the death penalty, because there are so few women, relatively speaking, under sentence of death, about 5% of the overall death row population. But the research shows that women who do receive death sentences, if you look at their proceedings, there's pretty overwhelming evidence of discrimination or of disregard for the woman's history of trauma, experiencing gender-based violence, etc. So Chris, can you speak to any of those issues and how they connect to the amicus brief?
I think you just did a good job of it, actually. But I think let me tease out a couple of other things that come up in the brief. So it's a great point. I'm glad you brought it up. So the first is that we do talk about it in essentially all the different contexts I just talked about. The question of discrimination comes up in each one of them, right? It comes up because it comes up from the question of history. Like the history of the death penalty is that, and we note this in our brief, is that communities have used the death penalty in particular to punish vulnerable groups, right? So there's a certain, like, for example, stonings in the past have been used for that kind of purpose, and we can't really escape that history, right? Where it's been used for out groups on the one hand and not on the other. So there's that history. But then there's also the fact that, and you're right with regard to women, and we talk a lot about the disproportionate effects on women. But I think even with other vulnerable groups, it can also be a class issue that reflects socioeconomic status. So that if you're not able, if one is unable to participate in the justice system in an equitable way, they're more likely to find themselves in the position of facing the death penalty as a more likely punishment. And so I think both of those reflect ultimately equity issues, class issues, issues of discrimination, and historical ways of keeping class and hierarchy in social systems.
Okay, thanks, Chris. So I want to give folks the chance to ask Chris and Tito questions. And if you prefer to type your questions out in the chat, you can do that. Or if you want to unmute yourselves, I think you should be able to do that to ask your questions. But I want to give you all the opportunity to learn more from Tito and Chris about what to me is a really interesting topic.
And if we get no questions, it's because we've done a perfect job explaining all of it.
Tito, I'd love to hear from you while we wait for others to chime in with questions about whether, I mean, the Advocates for Human Rights is based in the United States. The World Coalition Against the Death Penalty is based in Europe, but has members all around the world, including many members based in Africa. Is there any negative to having organizations based outside of Africa kind of chime in the form of submitting an amicus brief? And is there a way, like, would it mitigate that to the extent that there might be some negative component to that? Because, you know, who are we? Although the Advocates for Human Rights has observer status with the African Commission, and we have for quite some time. But nonetheless, is there any negative, and does it help matters if we reach out, as we plan to do, to members of the World Coalition Against the Death Penalty who are based in Africa, to have them join on as fellow amici for our particular brief? Tito, any thoughts about that?
Yeah, but I think that there might, there might be anything, but it might be stereotypes or individual attitudes of a judge or so. But well, as I alluded to earlier, they value expertise. They value expertise and a professional opinion which is built on on a good reasoning, like how Chris was trying to to show the reason as to why the argument should be accepted, and yeah. So I think the best way to capture their attention is to show why is it pertinent for the organization for the organization's contribution to be considered. But also, yeah, it might be viable to rally behind members of the World Coalition Against Death Penalty. I know Fulgence has been coming to the US, has been with the Cornell Law School for quite some times. Yes, he has. I mean, he's our death penalty guy. Yeah. So there's always a way to show that the organization knows the African context. It has worked in Africa. It has members, such that all these members also have fundamentally contributed to the jurisprudence of the court. Yeah. So there can always be things that we can't expect, but it's more important to show why the opinion should matter.
Great, thank you. I see Isabella has her hand up. We've already name checked Isabella, but go ahead, please.
Thank you so much. My question is for Tito. Our team, when we were preparing the amicus, was heartened to see multiple separate opinions by Judge Chikaya, essentially, cajoling the rest of the court for not using its own powers to ex officio decide that the death penalty per se was arbitrary, especially in the series of cases regarding the compulsory death sentence. His separate opinion has made very clear his position that international law is now settled on the illegality and arbitrariness of the death penalty, and his belief that the African court has a duty and an obligation to abolish it. And so I'm just wondering if you have any insight about, politically, how will this work on the bench? I imagine that he's already sought that kind of consensus from the rest of the members of the bench, and I'm wondering, does this bode well for the advisory opinion, or the fact that they have not bought in on his positions in the past? Do you foresee there being a challenge to a successful advisory opinion on that basis?
The thing is, so I got to participate in the vetting of these judges where Chikaya was being reelected. Yeah, so it is when we try to read his mind to a conclusion that he's probably not so much pro-human rights, if you wish, because he has not dissented in just death penalty cases only. He has been dissenting quite consistently. But again, him being of that outlook, then we thought maybe it's because of his position in the court. He was the vice of the court, and then he's one of the senior judges. So one thing that we concluded also is that sometimes it's difficult to see clarity in his dissenting opinions. So he might be clear in one way, but then you can't get the real gist of why he is dissenting, because he's not expressing himself to the finality or to the extent that he could be clear. And this was the opinion of the three professors we worked with in trying to analyze. I think we analyzed like 60 dissenting decisions, some of which he participated massively. Yeah, so borrowing his reasoning on this specific aspect of death penalty, it could be advantageous because he's still strongly opinionated about what he established, but yet again he has that controversial perspective on the bench. So it might inspire others to think like him, but also again his previous relationship on the bench. I don't know how they relate, but I think he has that tag of a dissenter. However, if recently I was chatting with the registrar on how to manage dissenting voices on the bench, especially when the matter is of huge political importance, because it then gives states, that selling card that, what, even judges themselves disagree, even though not on a majority or a relatively, close level, but then it gives states an opinion to say that, what, even the judges themselves disagree. So given the political context in which death penalty is practiced, for instance, in Tanzania, there's this belief that death penalty is justified by the major religions. Christians accept it, Muslims accept it, and this has been academically written by scholars. That this one has a justification. But then I didn't say this, but for over 2 years, we have had this presidential commission to look into the criminal justice system in Tanzania. And then one of the recommendations on death penalty, they said it has to be retained because it is, acceptable, but we have to guard the practice. So they are leaning towards removing mandatory death penalties in a way that aligns with the court's, interpretation of Article 4. And but they didn't at all say anything on the execution. So what they said is that it has to be, the law has to be amended with a view to, to giving the court discretion, but then they never said a thing on the mode of execution, which the court has said to be inhuman and cruel. So politically, it's, you can try to do a mapping of how the social science of death penalty works in Africa, or the political economy of death penalty, with a view to trying also to preempt some arguments from the bench that what will they say of this? Are they bold enough to say now we're abolishing? Or I remember one professor was very opposite of us saying blatantly that we have got to abolish it. So no, let's begin. Let us start with the mandatory death penalty, and then after some times we build on that. But then until when? Because who is going to be here 20 years, 50 years later to try to build something slowly? So if we know what we want and we know what we deserve, we better go for it. So Chikaya's argument might be persuasive in terms of building the jurisprudence, but then his personality might block acceptance by the rest of the bench, if you wish.
Thank you so much.
Great. Thanks for that question.
And also, sorry, there are two new judges. There are two new judges in the court. There's a Ugandan judge who is a pro-human rights. Yeah, I think they're both pro-human rights, but it's pertinent to also try to understand their philosophy of these controversial questions, if you wish, so that to gain more confidence that we can, if they have written on it, I think it can be used during research.
Great. Thank you so much for that Q&A. And we had a question in the chat as well. And I think this is a good question to wrap up on, because it's, as someone who doesn't come from a legal background professionally, how can someone like myself continue to learn more about these issues and, more importantly, contribute to meaningful abolition work nationally and domestically? I put a link in the chat to the advocates page on the death penalty that can get people started. But I also believe this is a great example of think globally, act locally. So the Advocates for Human Rights, if you're already volunteering for us, we would love to have a working group of volunteers that plans next year's World Day activities. It's every October 10th, and next year's theme is going to be the same theme. So we could start planning now what we're going to do. And, you know, it would be great to have a non-lawyer focused type of activity as well, or multiple activities. So we'd be really excited to get you involved there. There are also, especially in the United States, there are state-level organizations working to abolish the death penalty in their states. Minnesota abolished the death penalty more than 100 years ago. So we've been quite fortunate here where the Advocates is based. But there's a big campaign in Missouri to push toward abolition, and the Indiana Coalition is also working really hard. So you might reach out to them to see whether there's anything you can do to assist with their efforts as well. But you know, it's great to just start learning and get involved. If you go to our website, you'll see a lot of reports we've submitted to the UN on death penalty issues in a lot of different countries. And of course, there's the Death Penalty Information Center, which has a great database of information about death penalty practices here in the United States too. So there's a lot that you can do to get involved, and we would love to have you join the cause of abolition. With that, we've gone a little bit over, even considering our late start. So I really want to thank our panelists, Tito and Chris. I also want to thank my colleague Luisa, who organized this entire event, found Tito and convinced him to work late in Tanzania to help us out, help us better understand the African court. And of course, a huge thank you to the team, Chris, Isabella, the rest of the team at Foley Hoag for all of their great work on this amicus brief. We are eagerly awaiting the court's decision to accept the request for advisory opinion, and then to accept our petition to become a friend of the court and to submit this brief. So watch this space. We'll be updating our advocates website as soon as we're ready to file that amicus brief, and we'll be eagerly following the proceedings of the African court with our fingers crossed that all of this advocacy will be persuasive and the court will recognize that the death penalty is not compatible with the African Charter. So thank you to all of you for joining. If you are looking for CLE credit, we have applied but not yet been approved. The CLE code, which is also on our website, is 516110. That's again 516110. But we should be able to we'll anticipate that approval will come in soon. And again, it's on our website, and I can have my colleagues send out an email blast with that code if that's something that you're looking for. Thank you again. If you have further questions or follow-up, feel free to reach out to the advocates, and we'd be happy to talk more. I hope you all enjoy the rest of your day, afternoon, or evening, as the case may be. Thanks so much.
Thank you, Amy. Thanks, everybody.
Thank you.